Ravvi is graduated in international relations and also in law. He has just returned from Indiana University, and he was for a long time from Kaji, and he has the challenge of going ANPD to start to inspect everything, and he went to PD to cooperate with the authority in order for them to be enabled to have the role of a main character in what LGPD foresees. Ravvi, I would like you to talk a little bit. We will have a presentation about this, which is the building process of ANPD and how is it organized in order to monitor, inspect, and apply sanctions foreseen in LGPD. Is very important because we had the first fine. So give us some recent news about the first fine and what can we expect? We know some numbers have been already disclosed about inspection lawsuits and new sanctions. What can we expect from this? Okay, thank you very much, Vanessa, for the presentation. Can I speak on the other microphone? First of all, good afternoon to all of you. Can you hear me well? Good. There is a presentation. It's here already on the screen. First of all, thank you very much for the invitation. I would like to thank ABPI for the invitation. It's a great honor to be representing LPG here in this event. And we will start now talking about the subject of the panel, that are the applications, enforcement of sanctions of LGPD by ANPD. ANPD is a mixture of regulating agency and other body, because ANPD regulates, inspects, and sanctions. In this panel, we'll talk mainly about the inspection activity of ANPD. That's where I work. In Article 55J of LGPD are the main duties of ANPD, and among them we have to inspect and apply sanctions. Fifth, to appreciate requests against the controller. And number 24, to register complaints about the treatment of personal data. Besides the activity of inspection, we have also the law is structured in order for the citizen to be able to contact ANPD to have their rights foreseen in LGPD. And how can we organize this in ANPD? We have a macro process, 4 macro processes in the coordination of inspection that is in charge of the inspection of ANPD. We have the monitoring is in charge of receiving all the reports that reach ANPD, the requests done by the citizens. And what do we do with this? We have our statistics that give a report of the monitoring cycle. This monitoring is annual, and it is the look of the past, what is happening, what has the society requested to ANPD, in order then to have a map of priority issues. This map is looking towards the future. What we notice as a priority established by the society, and what we trace as our goals for future inspections. ANPD is a very recent body. We are structuring it, and we have to establish priorities in order to inspect LGPD. And as of these 2 tools, the monitoring report and map of important issues that we give priority. The inspection area is also in charge of the guidance of the regulating entities. And also, we have a preventive activity that is, many people think that it's only to inspect and sanction. No. Our main focus is to prevent the irregular treatment of personal data. We do this through another macro process of inspection. The idea is to bring all the entities in compliance with ANPD. And lastly, as the last resource of ANPD, that is the sanctions. So once we cannot bring them to a compliance, we will be obliged to enforce sanctions through a sanctioning lawsuit in the fourth macro process. So how is this division structured? For you to have an idea, speaking very briefly, LGPD was approved in 2018, only became effective 2 years after. ANPD was started in 2021. So ANPD doesn't even have 3 years of existence, but the structure was already foreseen in a decree, and the coordination of these four macro processes have three divisions, 3 units: the monitoring, coordination of safety incidents, and the coordination of inspection. That is the unit that I'm in charge of. The monitoring in 2022 had one civil servant during the whole year. He was in charge of following 80 reports of the society. When I talk about society, public prosecutor, citizens that represent 80 crimes per month. And then this year we have 2 other civil servants, so we have 3 civil servants now. And once the society has a knowledge of LGPD, the numbers increase. So we have an average of 100 per month. That gives for each civil servant to analyze 10 requests per day. The coordination of safety incidents have to do with safety incidents, hacking of data, leakage of data. So last year we had 3 civil servants and had about 20 incidents per month, reminding you that by LGPD, the regulating entities, the public sector also, they're obliged to report all the safety incidents, and we have also reports of others. So we had about 20 per month for 3 civil servants, and this year we're reaching 30 per month. They're already informed to LPD, increasing a number of civil servants. Comparing this, the French authorities have an average 2,500 incidents of safety per year, which gives about 200 per month. Considering the difference of size between France and Brazil, we believe that this number will increase a lot in the next years, and we have to structure ourselves. And this inspection and sanctioning committee had 3 civil servants last year, and now we have 5. And we forecast to increase until the end of the year. And we have requested from other entities, and it is well known, all the bodies have a lack of human resources, and many times we're not able to change from entity to another. So it's very, while there's not a public bidding for the analyst for data protection, that also in the radar of ANPD we'll have ready documents requesting this, the civil house, for, or at least to have another kind of approach to find a solution to this demand. So which are main tool to standardize is to the rule of the first resolution of ANPD, number 1 in 2021, once we were launched, was the inspection process. I work in coordination of inspection. We have 2 processes. The inspection process in Article 15 of the regulation. That is what I mentioned. The idea is to bring the regulated entity to compliance. It's not to punish. Once we have a report or we start an investigation against a regulated entity, we have to check if the data treatment is according to LGPD. If it is compliance, it's okay, and we end the lawsuit. If it's not, we try to identify the problem in the treatment of personal data, and then we have to establish a dialogue with the regulating entity, and we try to find a solution. That's what we call a responsive regulation, a dialogue between the authority and the regulating entity. They pass information to us in this inspection process, and we have to find similar grounds, which are the tools that regulation provides in order to adopt the preventive or corrective measures. There are preventive measures in Article 32. There are 4 preventive measures. If this dialogue with a regulated entity, they're not being at ease or they don't accept our suggestions, we can have preventive measures in the inspection process. Then this is foreseen in Article 32. In Article 32, paragraph 2nd, the non-compliance of preventive measures is worsens the sanctions. We're still in the inspection process suggesting that entity should adopt behavior in compliance with GLPD. Once they refuse or don't accept our suggestion, we adopt a preventive measure, and then if they accept it, okay, we end the claim, and if they don't accept it, then we go to the second claim. That is a sanction one, foreseen in Article 37 of the regulation. And then it's the punishment. We have ended all the arguments, and we go to a sentence. So the first document is infraction document and making a fine, a traffic fine. It mentions all the codes about all the issues that are described, which is the regulation that was not observed, preventive measure that was not complied in this infraction. That is the opening of the sanctioning claim. And this is a very simple process or procedure. These are the stages that are foreseen in the regulation, that once they are notified, they have 10 working days period. If they request a proof or evidence, we have the final allegations of the regulated entity, and then we have a report that is basically a gathering of everything that happened in this claim. And in this report, we have the dose metrics. That's another regulation. And finally, we have the decision of the general coordinator. The way the LGPD is, we are inside the coordination of inspection, and this part is all done in my division. And then I will send this to the general coordinator for him to give his final decision. I didn't mention it here, but there's a possibility of appeal to the council, GLPD. The first sanction happened a few months ago, as you have noticed by the media, and I'll explain how this appeal is done to the governing board. So once we have in numbers in the general coordination, the sanctioning process, we have 10 being judged now. 1 almost ended. They have already reached the end of all the appeals. And other 10, 8 involve public sector, and only 2 private corporations. Further on, I will explain why. Now, the inspection process that I mentioned before, in order to bring the company to a compliance, we have 16 that have been ended. That is, since ANPD was created in 2021, in less than 2 years, we analyzed 16 claims of inspection and ended them. 13 inspection processes are ongoing in ANPD with dialogue with the regulating entities. And you have these numbers and this information about the claims, the companies and public entities that are being inspected in the site of NPD, mainly in the tab of General Coordination of Inspection. And talking a bit about the sanctions of public entities, as I mentioned before, the idea of inspection is to bring to compliance. Most of the times the companies have heard ANPD and have complied positively or suggested for regulation. Or sometimes there was no need for any kind of measures. That's why we ended 16 claims and one or other became sanctioned. But in general, the private sector has had the best dialogue with ANPD than the public sector. That is a contradiction. ANPD is a public body. We have been in dialogue with other public bodies, but the best response has been from the private sector than from the government.
Passar para a parte aqui mais.
And to get to the more polemic part here, LGPD is the following sections: blocking data, publication of the infraction, and so on. Everything is indicated in the law. And suspension, partial system suspension of data bank, and so on, and very strong, which is prohibition of the exercise of activities related to data processing. So when we start, we can to speak up one of the sanctions here. And what we have as more strong opinions about this, and sometimes even asking to suspend the infractions, is concerns the simple amend. Simple fine, which is 22%. It is indicated in Article 52 in LGPD Act, and simple fine up to 2% of the billing of the company. In its last exercise, excluding the different apart from what you paid, and the last exercise, the last end of the exercise. And there is a limit, 2% maximum of 50 million reals. So the company has to bill like a billion reais. So from those 2%, we will calculate the simple fine, and we created the criterion, the guide to calculate the fine, the simple fine. So we classified the infraction, which is the first step, and then we define the sanction. It will be like just a simple fine and so on. And then we dose the fine, and if it's a monetary fine, and so on. And we have 3 levels to the simple fine: light, average, and very strong infraction. This is an exercise that we go from backwards. We have to see if the infraction is a light one or not, and if it's not, the 2 other ones, I classify it as a light one. So the average infraction has to touch in a very significant way the interests and fundamental rights. It depends on the authority to interpret which are the rights and interests that are affected in an interest way. The very strong infraction indicates in a closed list the following hypothesis that we see to the right, but it touches rights and interests, like if the regular processing of data is a risk to the life of a person, and at the same time it affects interests and fundamental rights, I can classify it as a very strong one. But if it didn't touch the life of a person, but it touched the fundamental rights, I can classify it not as a very strong one. And I told you about 1 to 2%. The dosage, we have 3 different doses of fine here. So the light one is 0.8 to 0.15%, and the average one 0.13 to 0.5, and the last one 0.45 to 1.50. When we classify as the 3 different steps, we see if there is ways to increase the fine or reduce it. We will do the math. If the company has a very low billing and we can increase to light, average, and strong one. And now to see after the kind of sanction, first sanction of a ANPD. This company offered data and for different usages, for those who wanted to treat those data, and here we have from the side of the company itself, like mass messages. According to the company, they had 130 million users and so on. And so fine at Ubatuba City in 2020, and we had the local elections, and this company got in touch with some candidates offering a number of WhatsApp numbers of some electors, some voters. And so ANPD was informed, and we opened a surveillance process against Telecom so that the company could explain why it was doing that sort of processing, and if it was taking into account the LGPD, and how did it have the numbers of WhatsApp for those people. They did not give us a positive answer, and it didn't comply with our request. And before getting to the conclusion, Telecom had an economic advantage of 10,000 clicks, 800 and up to 100,000 clicks, like 5,250. So the company was selling really those contacts of WhatsApp. As we asked the suspend the activities and do a report on the impacts of the activity, and the company did not respond, we opened up a process and gave her a sanction, DPO, and the company was sanctioned, and simple fine for 2 infractions. It's so we the Article 7 of LGPD, a lack of legal base for treating for processing the data, and infraction of Article number 5 of supervision regulation. It was like obstruction. As we didn't know how much the company sold a year, so we applied Article 11, Article 3, 2 of the dosing regulation and ANPD to indicate how much the company sold every year. Also, the fact that so it has to have a maximum of 360,000 sales a year. The fine could not be higher than 7,200 per infraction. So we had two different fines here for both articles of the law. So we have 14,400 reals. And some people wonder if we want to avoid being too harsh with the companies. What we want to take into account is the company is a small one with a small level of sales, and ANPD has other sanctions which can be more harsh to the company, like stopping the data processing. And we can even just close the company or a temporary suspension as well. So we have other mechanisms that are possible to be applied in these companies. And so what we do is to avoid getting to the sanction. What we want to do is to really supervise and a process or opened by ANPD or any other agency can be bad for the company. That's not what we want to do. What we want to do is how the company is treating this personal processing, and if the company is not doing well, it can stop what should be doing, and we just will not apply the fine, because we will only apply the fine if the company is not going to willing to cooperate with us. So we have different social networks here, and that's it.
Excelente, Ravvi. Acho que mostra o quanto que a
Excellent. This shows how this has evolved and how it will continue evolving, looking for not only the expansion of knowledge regarding the guardianship of personal data in the country, but also to convince everybody that they have to do something. It's not a lot of simply for you to read or to sell it in education programs that in practice will be demanded by all the authorities. I will pass the floor now to Judge André Gustavo. Very briefly speak, he's a judge of the Court of Justice of Rio de Janeiro, but as he prefers to be recognized for his presence and his teaching mainly in the School of Judges in Rio de Janeiro, it's an honor to be with him. He will talk about not only sanctions, but also LGPD has disclosed itself in the judiciary. There's some numbers that talk about 60 lawsuits involving LGPD, and we are also have a lot of the use of face recognition in the subway or any public transportation, and also that was approved by the Superior the protection of personal rights as fundamental. How does the dictionary see this, and what do we expect on the approach of LGPD in the judiciary? Good afternoon to all of you. I was in doubt if I was going to use this. I'm going to use it because I can regulate my voice volume. Very interesting, your presentation by Dr. Ravvi talking about National Authority of Protection of Data. I would like to have another counterpart talking about judiciary, how we see this, but I would like to give a brief explanation. Maybe it's redundant for you that are experts on this subject, but I would like to echo what Minister Barroso said at lunchtime during his speech, that I feel myself speaking to people that know much more about this subject than myself. But anyway, for me it's a great joy to be here, and my intention is to learn and then to give some knowledge. I would like to start a bit and give a small introduction talking about how have we reached this point. How have we reached this concern with the protection of personal data? We started to be concerned when we started what we call the age of information, digital age, so well explained by Minister Barroso this morning at lunch. Internet opened the doors of communication, digital communication, and allowed all of us access to an ocean of information. Of course, without any doubt, Internet has been a conquest of civilization for all of us and allowed us to hold business, buy and sell products. And also, I will advance a little bit more. It was very useful, mainly in a recent period that was the pandemic. What would be of us without the Internet, without the possibility through with the use of a laptop or a smartphone to acquire services and products and buy food, and all the workers that were very bravely facing the pandemic and exposing themselves to the virus and so on, while we were protecting ourselves at home. So without any doubt, the era of information, a great achievement. On the other hand, these great advantages brought by this, it has brought undesirable sub-products, as always happens when a new technology arrives. One of these sub-products that are undesirable, it happens that in fact it's in the essence or the core of the working of Internet, the collection analysis of data, data economy that moves this engine that is called Internet. And great part of this has to do with personal data. Data have to do of each of us. The trade of personal data is so embedded in our society that has been called of the surveillance capitalism or the capitalism of information. I recommend the reading of Shoshana Zuboff's book that she talks about this reality that we're going through. So it's a bit important to lead the forest in order to see the forest from far away. So when we use a laptop or a cell phone, want to look for a book on the Internet, be it in Google, Amazon, whatever other, I'm automatically sending data, my own data, that will allow then third parties to see my profile, what kind of literature I enjoy, which is my political ideology, which is the country, city where I live. If I buy the book, will I feed the site with other personal data, my name, address, gender, number of my credit card. And even if I go to a physical bookstore, many of these data will be shared also by my smartphone that will show my geolocation, how long did I stay in the bookstore. So this will allow to have the data set that will give information to third parties of my profile. This will be sold and shared with other people. That will sell to other people, a chain, a very extensive chain. So this data, after being treated, allows the third parties not only come to know our profiling, but what's more frightening, not only know our behavior and profile, but allow them to influence our behavior. When we finally perceived this reality and it was part of our life, much of our privacy had disappeared. One of the important cases, and I always mention we're talking about data protection, has to do with our privacy, how it can be invaded by manipulation of the data, was a famous scandal with Cambridge Analytics. Here I go to this slide. The scientists of this company developed an app called This Is Your Digital Life, and they were enabled the 70,000 users of Facebook downloaded the apps, and they paid $1 or $2 for each person to answer research that helped the data analysts to determine their types of personalities. This app then downloaded all the data of Facebook of the users to find correlations between personality and likes. And what is more frightening, that Cambridge Analytics also downloaded the friends of the Facebook participants without their knowledge. Summarizing, Cambridge Analytics deceived 270,000 people, betraying their friends for $1. Although the participants, they answered voluntarily the research, many of them probably didn't read all the terms and conditions, which and it wouldn't have warned them that their data would be badly used in order to influence the elections. And using the online connection of these people to download the maximum data, at the end they were able to have data of 87 million of users of Facebook in the whole world. So with this information, Cambridge Analytica had a psychological war in order to influence politics in the whole world. This is a didactic illustration as how knowledge is power. The data are considered such an important asset in modern life that it has been very common to see that the data is the new oil. This is a very common sentence. But the issue is, at what cost? Clarissa Velix, that I mentioned, how do I go backwards? Clarissa Velix published this book. She uses a metaphor that is quite appropriate. According to her, personal data are a technology society. This has always been a low-cost asset and very useful. It's our immortal product because it can bring cancer and other lung problems. But the personal data as can be mined at a low cost and used for a number of activities. They can be sold, changed. They help for prediction of future behaviors, but also as amianto, they are toxic and they can poison human lives. Not only human lives, institutions and whole societies. An expert in technological safety, Bruce Schneider, in an article in CNN, every week hackers invade the networks and they steal data about people. They use this to commit fraud, and every week hackers invade networks and capture data from people, dozens of millions once in one time. And some examples can be mentioned here among many others. For example, examples of many times there are information that allow to commit fraud like the one in 2015 with Experian, which database was invaded, leaking information from many users of T-Mobile company, telephone company. Likewise, the website of the IRS was invaded, obtaining financial information of 104,000 taxpayers. This case here is very cruel because wanted to embarrass and coerce. Clarissa Velix, she tells it in her book, this case. She says in August 18, 2015, 30 million people woke up with their personal data published online. Hackers had disclosed all the database of Ashley Madison customers. It's a site for matchmakers. They could be identified by names, address, preference, number of credit cards, and the hackers did this in order to give a lesson to the unfaithful for more repairs, as they wrote. Many became anxious and sleepless. Some lost their jobs. Surely many lost their marriages. Some were blackmailed by criminals that would tell their spouses that they wouldn't pay. And the threats were, if you don't comply with my request, I will humiliate those near you, dear to you. Even if the victim would pay for their silence, they wouldn't be sure that same criminal or another would not expose them anyway. In Alabama, and this is newspaper, printed all the people that lived in there, and a hacker opened a Twitter account and a site with obscene information. Marriages and families were destroyed, and some people committed suicide. Very well. So it was in this context that many companies started to adopt personal data protection laws. European Union, LGPD, this started in May 2018. More than 150 countries followed this trend, adopting laws for data protection. So this is a trend, the establishment of independent authorities to enforce the law.
As we have here in Brazil, like the Act of 2020 became a fundamental principle in our Constitution. So it's a fundamental guarantee included in Article 5, 79 in the Constitution of 88. Personal data protection has to do with privacy. It's a result or it's a specification, and which is acknowledged in different acts and regulations abroad. So that right to privacy comes from the principle of the human dignity. It encompasses different points like religious preferences, protection of communications, protection to the life and family, protection of image, protection against genetic assays, and so on. It wants to protect any information, including name, birth dates, and so on, numbers of telephone numbers and emails, and also other information like IP address, and so on. Data protection has as a goal to guarantee a fair treatment and according to the use and storage by the public and private sector. And here we get to the specific point, civil responsibility of agents in the processing in the our act in Brazil. It does not have a specific indication of how the data agents are going to treat and to manipulate this data, like what are the principles that will guide in different situations this treatment. It has to do with civil responsibilities here. Article number 6, paragraph 6 is safety, use of technical measures, administrative measures to protect personal access data which are not authorized, and prevention, which is fundamental, adoption of measures to prevent damage in virtue due to treatment of personal data, and also indication by the agent of adopting measures capable of proving the observance and compliance of what the law says. What is the nature of the responsibility from inappropriate treatment that may cause damage to a third party? Is it subjective or objective? What is the obligation, which is obligation of means or result? This is completely controversial in a sense or another. I went to a civil law journey that was first time treated in the commission that I worked in. The these issues. And the basic was the general law for data protection. And I suggested 2 points. One of them had to do with nature of civil responsibility. It was not examined by the plenary because it was so complicated to examine, and people just didn't want to discuss, and they said that it was better not to be approved. It's a form of subjective responsibility of a presumed form. So we have to understand and examine Articles 42 to 45 of the law. And as we can see, cause damage in terms of money and so on in violation to this law. That person has to stop. So, there was an expression of regardless of culpability. So in this article number 42, activity in violation of personal data has to do with subjective responsibility, not objective responsibility. Number 43, those will not be responsible if, as we can see here in Article 1, that they did not make the personal data processing that is attributed to them. 3, that has to do with processing of personal data. And 3, there was no violation to the law concerning data protection. So this editing has to do with objective responsibility. It's a pity that the lawmaker didn't indicate exactly what kind of responsibility, subjective or objective, was taken into account. Article 44, when the data processing does not supply the necessary protection. And 45 has to do with violation of the right in terms of consumer relations that are dependent on the rules of responsibility that are foreseen in the existing legislation. This system, from my point of view, is like an assumed fault. So it assumes the fault of the agent. But if he, with the burden of the proof, indicates what he could do to avoid the damage, what has the justice in general has been acting according to LGPD in protection of data? I have 4 different cases here, 2 of collective action, and the company Meta, which was called Facebook, was condemned to pay 20 million reais because it had leaked some data. It was like a collective moral damage. Here we have some details of the lawsuit. The second one was the ruling in São Paulo, which is very known. IDEC went against Via Quatro, asking to avoid collecting and processing of biometric data from passengers without prior authorization. So the tribunal increased the value of indemnity to 500,000 reals. The third one is an individual sued leaking of personal data, and we made a difference here between sensible data and common data. And the assumed fault was discussed, and we have to indicate if there is really a damage or not. Data of common nature, personal but not intimate, passable only of identification by the natural person, cannot be classified as sensible. And in and of itself, it cannot just by itself generate moral damage.
Ou não, adequado ou inadequado, ela traz aqui parâmetro para a gente.
And here we had at least a guideline to start discussing. What do we have to prove when it is a leak in the data that pertains to us? If it's sensible, we can indicate that is a damage. But if they not, we can also indicate that there was a problem with the reputation of that person and other things. I don't know if it is the best solution because of the Brazilian Constitution included the data protection to a level of constitutional guarantee, but that's what we have now. Another interesting case, and was judged by the Supreme Court. So I had two different superior courts and first level courts. Data of collection of information, exchange of babies, the hospitals and so on in Rio de Janeiro have to adopt security measures to avoid exchange of babies through the DNA exams in case of doubt. So article number 2.
De kit de coleta de material genético de todas as mães e filhos ali.
And we have to have DNA collected from all the babies and mothers in the health unit available to the justice. So what we have is to adopt this, and it was considered unconstitutional by the core.
Ok. Mas entendeu que isso seria uma invasão.
This would be an invasion of a hypersensible data. Has to do with genetic material from a baby, and we would never know at that point what would be the use of that DNA material. The more important thing here is
exactly what was very well mentioned by a colleague here previously, to have a culture for protection. Personal data treat much more important than try to understand how we have to be responsible. We have to create this culture to protect personal data, because we're talking about what has to do with our intimacy and privacy. Thank you.
Muito obrigada, doutor André. Acho que excelente apresentação aí.
Thank you, Dr. André, giving many insights, very important. I would like to open now for Q&A. I know there are a number of them, but if anybody wants to have any comment, the microphone is available for anybody.
Não. Se os palestrantes
If the speakers can speak a little bit more about responsibility and sensitive data. Because we're talking sensitive data, we're always talking about health, data, but we have to remember there's an enormous list of sensitive data, political parties and STJ's idea to have an assumption of moral damage. Can we hear a little bit more about responsibility and sensitive data? I think it's for Professor André. I recommend the reading of a very important book of Professor Chiaras de Tefé, that is a result of my dissertation that she defended this year. The book is brilliant, and she talks very deeply about the subject of sensitive data and why special protection of personal data, or to have the sensitive ones more considered. Something important that she, and I hope that this can be food for the jurisprudence. They're all listed in LGPD. They don't have a specific number. As the Constitution of Brazil says, personality is not what is indicated in the Constitution, but everything has to do with social evolution. Sensitive data are those that are being recognized by the jurisprudence as being part of the intimate inner part of the person. Political and religious priority. Sexual guidance also is very sensitive because it has to do with intimacy of a person. So to talk about this kind of information and data deserves a specific and differentiated treatment. Even if we understand the leakage of this data, personal data, doesn't bring any moral damage. In the case of sensitive data, the ones that are recognized by law or are going to be recognized afterwards by the jurisprudence, they deserve a special protection because you don't have to prove anything more. It's like the story of moral damage. You wrote the name in SPC. This affects the reputation of a person or a company. So I think it is very, very justified. Read the book of Claude Tefek. I think it's a classical issue. Okay, let's go to the next one, please. Do we have any other question? I think this is it. Thank you very much, all of you, for being here. We will remain here a little bit more. If anybody wants to have a tete-a-tete, we are at your disposal. Thank you.